Okay, class. So we're starting chapter 24, which is our consumer protection law chapter. Um, so we're going to continue with this chapter. I think we'll find that this chapter is somewhat interesting because this is laws that um, honestly touch and directly affect the things that we do as we transact with consumers. So we're going to see the other side of those transactions and the law that regulates and protects us as consumers. Um, in this chapter, this I like this visual because it gives us a feel for what we can expect and what we'll cover. So, consumer law obviously is a broad area of law, and we're going to start with product safety. I know that's not the order that the chapter presents it, but we'll start there, and then we'll get into the advertising, marketing, and sales, food and drugs, particularly as it relates to labeling. And then Truth in Lending Act, which is related to credit protection. All right, so that's kind of our roadmap for this chapter. All right, so the Consumer Product Safety Act, um, like many acts, it established an administrative agency, the Consumer Product Safety Commission, which has fairly wide and broad latitude to regulate the sale of goods, right? So what we'll find is that since we're talking about primarily federal law in this chapter, that there is a threshold test that the business must affect interstate commerce, right? Which means that technically, from a technical perspective, um, these laws wouldn't be relevant for um, business transactions that are entirely within one state or don't have um, an effect on interstate commerce. In reality, that's fiction. The idea that business is entirely within one state, it's very, very difficult to do, um, and it's a relatively low bar. For example, um, even if I have a local farm that I grow and get, on the truck, load my produce on the truck and sell at the local market, there's a good chance that perhaps I took out some financing. Well, if I've taken out financing, there's a good chance that the bank is either located in one of the financial centers, and unless I'm in North Carolina or New York City, there's an effect on interstate commerce, right? Also, it's difficult to get products and services entirely intrastate, right? That's just not the way business is done anymore. And it's a relatively low bar. So what we're really saying, what I'm getting at here is that the laws we talk about are going to cover virtually all business transactions because at some level, um, every business and every business transaction affects interstate commerce. That means commerce among the states. Either their supplier is interstate, the contract is financed, or I should say one of the businesses is financed, the customer um, is from out of state or is along a highway that facilitates a lot of interstate traffic. So we're pretty safe in assuming that everything that we're going to discuss in this chapter affects interstate commerce. All right. So the Consumer Product Safety Commission, well, first and foremost, is the standard setting body for um, that. Um, there are minimum standards, certain items and products that have been banned from sale to the consumer. These are your asbestos and your lead paint and things of that nature, right? All of that comes from this commission, all right? They also can ban the manufacture and sale of any products that pose unreasonable risk. Um, And the types of things you see here are inherently dangerous. Strollers, car seats. Anytime you hear about a car seat ban or recall, um, it comes from the Consumer Product Safety Commission. All right. Um, Remove from the market any product it believes to be eminently hazardous. And at first reading, that might not sound that different than number two, ban the manufacture of certain products. Three is really for products that it finds or that someone finds, either a consumer or a manufacturer, or distributor finds that there is an hazardous product. And so this relates to the recall, all right, the preclusion of sale, and also recall attempts to get dangerous products out of the hands of the consumer. So if you've ever been contacted after you bought something, and there's a good chance you have, because there's usually recalls on cars or sometimes food items and toys and tools, and so there's a good chance that you've been party to a recall. And the response depends. I mean, sometimes it's bring it in and allow us to make an adjustment. Other times, more like if it's food, you just bring it back and we'll give you what you paid for it back, or allow you to trade it for a non-tainted version of the product. Um, Requires manufacturers to report on products that are already sold. So obviously the Consumer Product Safety Commission is not going to know how many units of a product has been sold without cooperation from the manufacturers and retailers. And it requires that they be open and honest in their communications with the Consumer Product Safety Commission, or the CPSC, which facilitates. The idea is that we've got a dangerous product out there in the open, and we want to know how many people are potentially affected, and that dictates the recall response. And the last piece is there are other pieces of consumer legislation. Some specifically relate to um, cars, others specifically relate to um, strollers and car seats. Um, and the commission administers those as well. All right. Um, so that's our fly through, our run through of what the Consumer Product Safety Act does. Okay, let's talk a bit about advertising. Um, and so the Federal Trade Commission Act, again, established the Federal Trade Commission, or the FTC. And the idea here is deceptive trade practices. So the idea originally in the early 1900s was buyer beware, consumer beware, you know, and let market forces dictate um, consumer behavior. So what I'm saying there is I go support a business and the product is either of poor quality or is harmful, or it doesn't live up to the advertised claims. Well, I'm going to be disgruntled. I'm going to have bad word of mouth, and I'm going to tell everybody I know not to buy this product. So that is basically buyer beware. Um, and there's some inherent problems with that. And also, it allows for consumers to be harmed um, by deceptive products um, from unscrupulous businesses and advertisers. So the act was signed into law to preclude those types of injuries and pecuniary losses, monetary losses. All right. And the main types of deceptive advertisings are claims that appear to be based on factual evidence but are not supported by fact. All right. And there are a bunch of examples. I'll link to many of these in the course. But for instance, Duracell makes batteries, and they came out with this ultra battery a while ago. And they advertised that it lasted longer than um, its own regular batteries. Obviously, the ultra batteries cost more, and also longer than any of the competition, which is a fact, right? If you can take a battery and put it in one device and turn it on and time how long it goes before the battery dies, and then you can do the same with the ultra battery, then there's your test, there's your factual evidence. Well, when an independent consumer testing agency tested these ultra batteries, they found that they were virtually identical um, to any other battery on the market. It didn't substantially extend battery life. So that's an example of a claim that appears to be based on factual evidence, but is not supported by fact. So what does this mean? If you're selling something and make a factual claim, that's not an opinion, that's something that's factual, um, you cannot you can't say a factual claim unless it's actually based on fact. Now, that doesn't preclude opinions like this product is better than the competition. That's an opinion, or this product is awesome, or this product will change your life. Those are opinions. But anytime an advertiser makes a factual statement, it needs to be based on factual evidence. Um, Half true claims. So these are claims that maybe some testing was done, and there's a half truth, but the advertising doesn't give light to the entire picture. All right. This could be like a nutritional supplement that um, increases um, energy for a period of time. And so, and I'm making this up. I'm making this one up, but if, for instance, 5 hour energy increased your energy for 5 hours, but then had a crash at the end where you had to fall asleep, but they only advertised the 5 hour period where you had the increased level of energy and focus, that's a half true claim because only advertising that piece doesn't give the full picture and can result to um, in deceptive advertising. Um, Celebrity endorsements. Um, so in a celebrity endorsement, the celebrity does actually need to use the product. Um, in the media for this week, I've linked the Shaquille O'Neal Buick commercial. And if you reviewed the media before you review the lecture, you're probably wondering, why did I do that? Is the office square again? And so, no. So Shaquille O'Neal was a pitch man for Buick. He's been one of many. Tiger Woods was pitching for Buick as well. But in that particular ad, he's advertising a particular car as large. And the idea is that it's a roomy car because Shaquille O'Neal is 7 foot 2 inches and over 300 pounds. Um, the problem with that is that subsequent to that ad, uh, after he ceased to be a Buick pitchman, he made some comments on a TV show about, if you look at towards the end of the video, it kind of looks like he's crammed in the car and he's pretty much virtually sitting in the back seat. Um, and so he made some comments to the effect that the car was too small for him and that he didn't necessarily drive around in a Buick. Um, to be clear, that really wasn't actionable because the Buick came out and said that they did actually provide him with the vehicle that he drove around for a period of time. So he did actually use the product, even though subsequent to the contractual agreement and the commercial being filmed, he may have ceased using the product. All right. And then, of course, bait and switch, which is usually you advertise for a very cheap product that is not in stock, or maybe if it is in stock, the salesperson doesn't want to tell you or show you that product. They want to sell you or show you something that is more expensive, often substantially more expensive, and um, more profitable to the company. That's bait and switch advertising, which is also a deceptive advertising practice. All right. Um, in the same vein as advertising, um, what happens when a business is found to have engaged in deceptive advertising? So it starts with a formal complaint, and you as consumers do have a pipeline to the Federal Trade Commission. You can sue on your own behalf as well, but you can also make a complaint. There's a spot on their website, and I believe they have a 1-800 number. And if they get enough of these, uh, they being the Federal Trade Commission, they will start and institute a formal complaint against the company. Um, and this is not litigation; they're not being sued. It's more of it's almost akin to a cease and desist, and so the company can uh, do that. They can comply, um, and in many cases make changes to their advertising. And oftentimes that'll be where it ends. But in more egregious cases, there may be an order, um, a specific order from the FTC to cease and desist, i.e., stop what you're doing. Counter advertising, which is the exact opposite. So, um, if the business was advertising in a deceptive manner, the counter advertising is going to get the accurate information out, which it's called counter advertising because it usually tends to contradict the previous advertising. Businesses don't like to do this, um, but the FTC can order it. All right, and usually there's not very memorable advertisements because companies are compelled to do it, so they're not going to pop and they're not going to flash. They're usually the fine print or the advertisements that um, aren't really very catching, right? Because the company is being compelled to do it. They don't want to. Um, they don't want it to be as catching as the original advertisement that was found to be deceptive. All right. Damages. Um, let's talk about the Skechers Shape Up shoes. You guys may remember those. And the celebrity pitch person was Kim Kardashian. Um, and Skechers advertised that they would um, shape and sculpt the thighs and bottom buttocks area, and it wasn't true, right? And you may remember these shoes. I'll post a picture, but they had the curved bottom, and they caught on. I mean, they were, I don't know if that you'd call it a fad or a trend, but a lot of mainly women, I guess some men wore them too, but a lot of women were wearing these shoes. Well, um, they didn't do what they said they did. They didn't actually shape you or sculpt you or make you get a booty like Kim Kardashian. It just didn't work. Um, and so um, they had to pay damages, right, in the amount of 40 million for certain individuals. If you own the shoes, um, you were entitled to damages. In some cases, they had to buy the shoes back. Um, and so that's an example um, of damages. It is also worth mentioning that the Lanham Act, you may remember from the intellectual property chapter, also has a claim for false advertising. This really isn't enforced by the Federal Trade Commission. This one is available to consumers or businesses who want to sue their competition for false advertising. All right, and the elements are injury to a commercial interest. So if I'm in a business and my competitor is advertising either in a misleading way about their own products or in a misleading way comparing my products to theirs, that could be harmful to my commercial interest, i.e., it cost me money. All right. Um, and that loss is caused, and I can prove that it's caused. It would be my responsibility if I were suing a competitor. It would be my responsibility to prove that that advertising is the cause of my financial loss, and also that the advertising was deceiving to buyers. Then I can sue under the Lanham Act for false advertising as well. Now, again, that's a bit different because most of the advertising stuff we talked about up to this point was initiated by the Federal Trade Commission. And to be clear, not entirely. Consumers and businesses can sue under portions of that as well, but most of that action comes directly from the Federal Trade Commission as a result of consumer feedback. Under the Lanham Act, um, there's very little federal oversight. Well, let me not say it not that way, but there is cases under this act are civil cases from one business to the next. Okay,